Alright folks, buckle up. This courtroom clash is about to tackle one of the thorniest legal debates out there. When does a disturbing idea turn into a criminal act? Let's break down the battle over probable cause and the mysterious role of missing evidence.
Your Honor, in these cases, we're not saying that probability can't be there. What we're saying is probability can be there so long as you have one piece of material. You have to have one piece of material to say that there was two children involved.
Where does that case say that?
The case...
Wait, did you listen to my question? Do you have a case that stands for the proposition that despite testimony, that I have to have that CSAC?
So
it does call the case of the People's State of Michigan versus Zachary Radcliff. Counsel, appearances, please.
Good afternoon, Your Honor. Amy Rise on behalf of the people.
James Thomas on behalf of Mr. Radcliff.
I didn't know Johnny on behalf of Mr. Radcliff.
Where we left off at the last hearing, counsel was making argument regarding the absence of CSAM and the legal inability of the court, and if that were the case,
Here's the twist. Defense argues that without actual material, the court's hands are tied. But remember, legal interpretation isn't always about what's there, it's about what could be proven. And that nuance? It's where legal wars are won or lost.
Find a defendant over. And I asked for regarding that issue. I received a brief from you. I don't think that the brief, I'm sure the brief did not address the issue that was raised for the court. It addressed something else, unless I am mistaken.
May I, Your Honor?
Yeah.
Your Honor, the court asked for us to present a brief that addresses the question of whether or not material was necessary. Child sexually illicit material was necessary. That's the brief that we submitted to the court on an argument of statutory interpretation and the category of criminal liability that the theory of the prosecution presented in testimony. I'm happy to go through that argument if that helps the court clarify.
You would need to, because as I read the brief, it doesn't address the issue that you brought forth to the court. I would also indicate, and I'll let you go ahead, but I would also indicate, I think it's in footnote 2 of your brief, that's a bit disingenuous if the court did not permit you time to go through a transcript. And I get a little bit sick and tired of that because the court has tried to provide everybody an opportunity to bring whatever issues it can before the court. And for you to say,
oof. That wasn't just legal disagreement, that was a bench-side burn. The judge just called out the defense for implying bias in the record keeping. Pro tip, accusing the court of being unfair? Not the way to win points with the bench.
That the court did not provide you opportunity to go through a transcript. Not in terms of a transcript, because one was not prepared, nor did you demand one. In fact, so that the record's clear, you requested of my staff a video of the proceeding. You requested that on Tuesday, the 25th. That video was expedited by my staff and given to defense counsel on Wednesday morning. So all of that really should have been put in there so that that's not an issue in the future. I think that that is more than adequate time to prepare the issue before the court. You may go ahead with your argument.
Thank you, Your Honor. Your Honor, for the record, I would like the record to reflect that we did not receive the state's response till after 5 o'clock on Monday, as the court directed that we should have received it before 5. Regardless, Your Honor, I would like to...
That caused you any prejudice?
Your Honor, I'm just placing it on the record.
No, but has it caused you any prejudice?
In a sense, Your Honor, it had, because if we received it before 5 p.m., then that would have given us more time to evaluate the state's position. But we understand and we...
Position, counsel. Another disingenuous argument. Go ahead.
Your Honor, the state...
Here comes the heart of the prosecution's theory, coercion to produce videos. This is where statutory interpretation collides with gut punch testimony. Can intent to create material be enough if no files were recovered? Let's find out.
Conceded in their response that Mr. Radcliff falls within the first category of criminal liability under the statute and under People versus Adkins. That category is a person who persuades, induces, entices, coerces, causes, or knowingly allows a child to engage in child sexually abusive activity for the purpose of producing any child sexually abusive material. The state's theory is that Mr. Radcliff did this by encouraging the alleged victims to make masturbation videos and email them to a Yahoo email or upload them to a Snapchat account provided to Trooper Ryan by the alleged victims. Your Honor, under People versus Willis, the Supreme Court in their order 1574652 stated, only as it pertains to this group, the first group as I indicated earlier, must a person act for the purpose of producing any child sexually abusive material in order to violate the statute MCL 750.145C2. The state has failed to elicit any testimony showing the probability that the coercion of child sexually abusive activity was for the purpose of producing any child sexually abusive material. Child sexually abuse.
Now this is key. What exactly qualifies as child sexually abusive material? It's not just the act, it's about recorded content. But if the files never show up, can testimony alone get you to probable cause? That's the million-dollar legal question.
So material is defined as child sexually abusive materials defined as a developed or undeveloped photograph, film, slide, electronic visual image, computer disc, or sound recording of a child engaging in the list of sexual acts. We agree that the act that's elicited here or that the state concedes is masturbation as well. The state conceded that no evidence of child sexually abusive material was testified to and relies on evidence still being processed. This court cannot consider evidence that has not been presented. Evidence that it's at a crime lab still being evaluated is not evidence that was presented at the preliminary exam. The state also relies on two cases, People versus Sturza. The state relies on People versus Sturza. They indicate in those cases that the court affirmed the conviction. Your Honor, in that case, the defendant didn't fall under the first category. The theory of guilt presented by the state was that the defendant fell into the second category or even the broader third category. Your Honor, in addition to that, when we look at the jury instructions for child sexually abusive activity causing or allowing, that requires some form of material. As I presented that definition to the court, that element is needed under that jury instruction that the child abusive material be a picture.
Defense is hammering the absence of physical evidence like a drum, but the state might argue, if 9 victims tell a similar story, does it really matter if the hard drive's empty?
Picture, movie, or illustration made or produced by any means. No evidence of that form of material was presented in this court during the preliminary exam. Probable cause requires a quantum of evidence sufficient.
It's not true, is it? I mean, you have the testimony of these 9 witnesses, or at least 7 of them.
That is correct, Your Honor. But in the end of those, none of the testimony referred to actual material as is defined under the statute. Material requires a photo. It requires an image of some form, a video, whether developed or underdeveloped. It could have simply been undeveloped negatives of images. Nothing of that line was presented during testimony. Trooper Ryan testified that he reviewed a camcorder and 7 videos that came with it. None of them contained any material that was child sexually abusive material or child sexually abusive activity. He testified that his first Snapchat warrant came back and had nothing that supported that form of material. He testified that Google came back and found nothing from the witness Weston's Google email address that supported child sexually abusive material. He also testified that Yahoo came back in relation to the Yahoo email address that was provided to Trooper Ryan from one of the alleged victims, that nothing came back from that address. Nothing was testified to during preliminary exam that meets the definition of child sexually illicit material. And given the fact that the state has conceded.
But witness says, I produced this movie. And this movie falls within the definition of the prohibited materials. You're saying that's not enough.
Your Honor, that is correct.
That's the case I was looking for,
So,
and where I don't have one.
So, Your Honor, the Supreme Court indicated in their order in Willis that that's a question that's being presented here. Here, we're asking this court to look at statutory interpretation. When we look at statutory interpretation, we first look at the plain language of the statute, whether it's ambiguous or not. In Atkins, the court looked at that statutory interpretation, determined that because of the first form of criminal liability does not have an or between child sexually abusive activity or child sexually abusive material, it requires the form of material. If the state had made any other argument, then we would have a different conversation. Here, the state's theory in this case is that Mr. Radcliff coerced, encouraged, gave an idea to these alleged victims. That falls under the first prong, the first form of criminal liability. Therefore, the state has to produce a form of material. That prong is to protect the community from production of child pornography. If their argument is that that is what he did here, the law requires them to present a form of material. The court may ask for a case on point, Your Honor, but we know how cases on point are created. They're created by these forms of challenges. So that is why we're bringing this challenge before the court to evaluate this case, listen to the state's argument that they are placing Mr. Radcliff into the first category of criminal liability. The state has lifted that. They indicated that in their response. They conceded to it. So therefore, they are required to present some form of child sexually illicit material to fulfill that criminal liability portion under that first category. For those reasons, Your Honor, we ask this court to deny bind over on the charges that are associated with child sexually illicit activity, charges that are associated with
Defense is going big, asking for total dismissal of the most serious charges. But are they reaching for a legal technicality or exposing a real prosecutorial hole? Stick with this one, it's far from over.
Aggravated child sexually abusive activity, as well as charges associated with using a computer or internet to commit those crimes. We also request this court to deny bind over on the other counts, count 1, count 5, and count 33 of this case, as discussed in our last day of preliminary exams.
Response.
I listened to counsel state that the statute requires some form of material. The state has to present a form of material.
The prosecution hits back, accusing the defense of trying to rewrite the law. This isn't about what should be, it's about what is. In the judge's eyes, that might be the difference between bind over and bounce out.
They are required to produce some material. What counsel is asking, Your Honor, to do is to rewrite the legislature and add an element to the crime that doesn't exist. They keep citing to the order in Willis, and it's an order. The defendant's application for leave to appeal for his conviction for child sexually abusive activity was denied by the Supreme Court. The court goes on to provide a synopsis of the child sexually abusive activity and the definitions therein, and indicate that the defendant has nonetheless raised pertinent concerns regarding the breadth of the statute that may warrant further review by the legislature. So I don't think I need to tell counsel that this is not the legislature. This is a court. The standard before the court is whether there's probable cause that a crime was committed and this defendant committed it. And that's the standard here today. To write something in a pleading to Your Honor that she didn't have time to obtain a transcript or somehow she's unfairly disadvantaged, there's nothing in that transcript that would indicate that we have to produce child sexually abusive material. The statute is clear, and we're not conceding. I didn't concede that there was no evidence of CSAM. Every single one of those victims testified to the coercion, the request, the sort of grooming of the defendant in obtaining this CSAM from them. He gave them the address. He told them how to do it. He critiqued the videos. So there are no physical videos at this time, but there was evidence about those videos. They all uploaded it to the address he gave, to the Snapchat he gave. So I'm not conceding anything. There is no requirement. Counsel argued before Your Honor on Tuesday, the 25th, that there had to be a video. Your Honor gave her a break to go get that case law and then an adjournment until Friday. The case law doesn't exist. There's no requirement. This is a probable cause standing. All of these victims came before Your Honor and testified to the grooming that happened by this defendant. He coerced them into making them feel like this was a normal thing for a 15-year-old boy to masturbate on a video and send it to their mentor at the church. He made it seem normal. He coerced. He allowed them to do it, and they were all under the age of 18. The fact that my response to her, whatever that was.
Let that sink in. Each video could potentially be its own felony count. The stakes? They just skyrocketed. Suddenly, we're not just talking about a few charges. We're talking dozens. Welcome to the high-stakes zone.
She filed on Friday because it wasn't any case law to support her point. Arrived at 5:06 p.m. She claims she's disadvantaged. I mean, this is really unbelievable. And so I would just ask, Your Honor, the evidence for all of the counts, for each of those victims, they engaged in child sexual abuse activity by masturbating naked in front of a phone, their cell phone, and they did that at the request and coercion of this defendant, and then they sent it to him on Snapchat, on email. And so there's no requirement that those videos be recovered. That can be an issue for the trier of fact. She can argue that all day long in front of the jury. She can make that argument to them that there's no video, so this didn't happen. And that's going to be for the jury to decide. And so we would ask that you bind over on all of the child sexually abusive activity counts. There's one for each victim. And I suggest to this court that this case law suggests that for each victim, I could charge one for each video they made. So there could be multiple counts for each victim. And the CSC1 charges with the victim Cole and with the victim Jacob, the testimony was very clear before this court that the defendant held a position of authority in the church. That's how he met both of these victims. And again, it is our position that he groomed them. And Cole was under 13. And I'm saying his name Cole. I believe that his name was Christopher in the record. Yes. Christopher testified that he was under the age of 13 when multiple penetrations occurred. He turned 13, and total in all, he's estimated 15 penetrations under the age of 16 at the defendant's residence when he met him at the church, when he was in a position of authority over him at the church. So there is definitely probable cause that those 6 counts of criminal sexual conduct in the first degree were committed, and that this defendant committed those. As well with Jacob, he testified to...
If I may stop you just for one moment. On the issue regarding Cole or Christopher, there are 6 counts. Are the 12, 13, 14, are those in the alternative to 15, 16, 17, or in addition to?
No, Your Honor. The 3 counts of CSC with a person under the age of 13, those are the penetrations that occurred when Cole was 12 years old. Gotcha. There's no showing that I need to make that he was in a position of authority, just that he was over the age of 17 and that the victim was under the age of 13. And those 3 charges carry a mandatory minimum 25-year sentence if the defendant is convicted. The additional 3 counts, the penetrations for Cole, would occur when he's 13, 14, or 15, and the defendant is in a position of authority at the church.
Got it.
So although Cole testified to 15 penetrations, I have charged only 6 of those. 3 when he was under 13, and 3 when he was between the ages of 13, 14, and 15. And the defendant was in a position of authority.
The reason that the court is asking is, like you said, with the individual events on the CSAM and aggravated CSAM, if the testimony were to reveal the people, and the court heard the proof, believes the proof, could add counts.
Yes, absolutely.
And so and part of my reason for asking, because I'm still trying to make a determination of this, if those are pled in the alternative, that would be a potential of really 24 counts, but 12 that he could be convicted of. If not pled in the alternative, then given the testimony, there could be an additional 9 counts. My math being that starting with the 15, 3 specific to 13, but there always is this relationship issue.
Correct.
Okay. All right.
So I do believe, certainly for probable cause level, that there is sufficient evidence to bind over on the penetrations for the victim identified as Christopher, that I'm now calling Cole. Additionally, the CSC counts for the victim identified as Jacob. He testified to two very distinct penetrations. One occurred when the defendant, of course, was in this position of authority, had access to that victim at the church when he was 13, 14, or 15. The first penetration occurred in the vehicle outside the victim's home. And the second penetration occurred the following summer in the defendant's vehicle in the church parking lot, both located within Washtenaw County. And I believe that there is sufficient evidence that he was in a position of authority. That's how he had access to Jacob. He still continued to see him at the church. And again, in line with the defendant's sort of grooming of all of these young men, he friended him on Snapchat, knew he sort of was in a vulnerable position with his parents, and the victim snuck out of the house for the defendant to sexually assault him, not once, but twice. And so we would ask that you bind over on both of those counts of criminal sexual conduct in the first degree. And his age, he testified to, was under the age of 16 at the time that both of those occurred. And for the reasons previously argued, and the testimony and the lack of support from defendant's argument about their need.
Prosecution is painting a full picture now, not just one act, but a pattern, a method, a system. Grooming, coercion, payment. This isn't about a single incident, it's about alleged systematic exploitation. And the jury? They'll have a lot to sort through.
Needing to be a video, that just isn't a requirement of the statute. There's certainly evidence in this case, and I won't reiterate and read all of the charges again, but there is evidence that the defendant persuaded, coerced, enticed these young men to engage in child sexually abusive activity. And in fact, they did. And it was for the purpose of producing this video, which they also testified they did and sent to him. He also paid them for it. I mean, he really fits in all 3 categories because he financed this. He paid them money. He bought them items. So we would ask that you bind the matter over to circuit court on all of the counts contained within the felony information, with the exception of count 1 for Holly Jordan, count 5, and count 33. We did not hear testimony on those counts, and so we would not be moving or bind over on 1, 5, and count 33.
No further defense.
In response to the state's position, you heard the state indicate coercion, indicating that their argument is that Mr. Radcliff, coerced these individuals into making the videos. The defense is not trying to rewrite.
Counsel, under the statute, Would that matter?
It does, Your Honor. Under the statute, coercion falls under the first criminal liability under Adkins. That is case law. It is case law presented by the Court of Appeals that divides criminal liability under the statute into three categories. First, being the coercion piece, persuasion. That category is what they have put Mr. Radcliff in, and that category requires the form of material or for the purpose of producing material as defined. So, Your Honor, we're not trying to rewrite law here. We're trying to refresh the court's memory on the fact that interpretation of the law has been made here. Adkins created three criminal liability categories. The state chose their theory of guilt. They chose how to ask their questions. They presented that evidence and presented a theory of guilt based on coercion. They placed themselves in the first category under Adkins.
So that,
if I may, Your Honor.
It certainly can be addressed in terms of coercion, but go ahead.
In addition to that, Your Honor, Mr. Willis didn't fall under the first category. The defendant in that case fell into the second category. There was proofs presented that dealt with arrangement or attempting to make arrangements. In addition, the same goes with the case that they relied to Sturza. In that case, category 2, maybe even category 3, broader. In that case, there was arrangements. There was testimony that was pulled that dealt with that information. Here, the state didn't have that theory of guilt. They didn't present that testimony. And now at the end of oral argument, they're saying, well, he could be under every category. Your Honor, the state chose their theory of guilt. They presented their theory of guilt, and that was coercion. That was encouragement. That was the allegations that Mr. Radcliff told them about this as an idea, right? That's what led to the actions. The state also says in their response that Mr. Radcliff requested. He didn't request this information. There was no testimony of that. Many of the victims indicated that he suggested the idea. They did nothing because they felt it was awkward or inappropriate, but later chose to reach out to him and ask if they was still an option. That's not a request that was testified to. That was an idea that was presented and a victim choosing.
An idea presented to a 13-year-old.
And that would fall under the coercion encouragement. Your Honor, the court defines encouragement as if I may, defines encouragement as to attempt to persuade or to spur on. And they do that in Sturza, the case that the state is relying on. So if that is encouragement, that's the idea that was presented. That places Mr. Radcliff in the first category by the actions of the state. Therefore, the state has to meet that burden of presenting material here.
But you're making that up about material. Again, give me a case that says that. I'm not here, hold counsel. I'm not here.
:06. And there it is. The judge slams the gavel, not literally, but rhetorically, shutting down the defense's attempt to force new legal ground. I'm not here to make law, she says. Translation? You argue the law as it exists, not how you wish it worked.
For some, educational experience of statutory interpretation. I'm not here to do that. We have the law that we have. And you may not like it. There are plenty of laws that I have to enforce. I may not like.
That is correct.
But I can't go just making up new law. That's not my job as a judge.
Your Honor, the law is the statute. Am I correct on that presumption?
I don't answer your questions.
Your Honor, the law here is the statute that the state is relying on. The statute has been broken down in Atkins case law presented to this court in those three categories. That's case law, Your Honor, that we are presenting to this court. Unless the court can find.
None of that says they have to have the